and a very warm welcome to yet another action-packed edition of the program CAC Weekly. Now, CAC Weekly is that program that keeps you abreast on the activities and the achievements of the Corporate Affairs Commission. My name is Medina Azaki. Coming up, CAC partners with the University of Abuja to promote entrepreneurship. The Business Facilitation Act and its relationship with CAMA 2020, amongst others, gets scrutinized. Plus, how to register an association, club, or a faith-based organization seamlessly online. These and more after the break. Stay with us.
May I wish to draw the attention of all of us here that corporate affairs is among the agencies we have identified that is building the block that will take Nigerian public service to be among the first 20 in the world by the year 2025. It is noted that so far they have met all the criteria. The challenge here is how do they sustain this success story to 2025. Thus, that is one of the reasons why we've asked them to come here, so that we hear what they have done and we give other agencies like this to learn from them, improve the quality of their their service delivery, and see how we can collectively move on the fortunes of Nigerians. We have high anticipation of the fact that at the end of this seminar, our guest speaker will have taken us through the current reforms, innovation and challenges of Corporate Affairs Commission on the growth of Nigeria's economy.
Welcome back. We start up with a history-making event and a potential employment generator. Owning a business name will soon be a requirement for graduation from the University of Abuja, says the University Authority. This was disclosed at a lecture tagged Importance of Business Registration, which is part of the institution's efforts to promote entrepreneurship and generate employment opportunities for Nigerian youth. Speaking during the lecture series organized by the university, the Registrar General of the Corporate Affairs Commission, Alhaji Garba Abubakar, highlighted the benefits of business registration, including legal identity, legal protection, operating a business account, access to loans, obtaining a visa, and getting all rights accorded to businesses and companies in Nigeria, among others. Represented by Habubala, the CAC scribe rolled out steps to ensure successful business registration in real time on the company's registration portal, the CRP. He also used the forum to highlight the Commission's reform initiatives and other impacts on the business environment, and therefore enjoined the students and the general public to leverage on the opportunities provided by the CAC reforms to register their companies. Also speaking, Professor Abdul Razak, Director Center for Entrepreneurship, underscored the importance of the registration, highlighting its vast potentials for the economic growth of the student. He added that the university was collaborating to start off the scheme shortly upon obtaining a waiver from the CAC. Some students who spoke to CAC Weekly applauded the University of Abuja for the initiative, which they say will go a long way in reshaping their approach to entrepreneurship within and outside the campus. Highlights of the event include a question and answer session. Wow, that sounds interesting. Kudos to the CAC and the University of Abuja. Now let's move to business facilitation matters. You may recall that on February 14, 2023, His Excellency President Muhammadu Buhari, GCFR, signed the Business Facilitation Act, commonly referred to as the Omnibus Act. Many commentators believe that the law will enhance growth in the micro, small, and medium-sized enterprises, that is the MSMEs sector of the economy. To get a further insight on the provision of the Act and its impact on CAMA 2020, let's join Mr. Adeola Tolulokbe Sonaike, Assistant Director, Registrar General's Office, for the second part of our discussion on the Business Facilitation Act. Please enjoy.
Then you have Section 207, which again, this is again necessary it is for completion, is to provide clarity. There's what we call prohibition notice, right, in a floating charge.
What's
Now,
prohibition notice?
okay, just like the word says, don't do,
Okay.
right? Now, there is charges, right, can be either of two forms, fixed or floating.
Okay.
Now, when you talk about fixed charge, you usually refer to them, holders of fixed charges, as secured creditors. And why that is so is because when you say fixed charge, from the word, it means that a charge means an encumbrance, right? A burden
Okay.
on a company property in this instance, right? So if you borrow money, companies need money to prosecute their purposes. They need money to carry on business. So you find out from time to time, companies will go and borrow money, maybe from the bank or from other lenders,
Yes.
financial institutions. And for these lenders to give you money, they want assurances.
That you pay back.
Exactly. So if you have properties, right, fixed properties, for instance, your land, the company has the land, has a house, a building. You use that to secure the loan. It's called collateral.
Yes.
Now, holders of such security, right? Okay, are the ones you call secured creditors. That kind of charge is what we call a fixed charge because there is a particular fixed property to secure it. So, in case of anything, if for some reasons the operations of the company goes south, right, and it finds itself in murky waters, those people that already have a particular property in their name to secure their loans will just move against that property. They don't have issues. That's why they call them secured creditors.
Okay.
Right?
Okay.
But there is the other kind of creditor, of lender, that is willing to take the risk and say, no, okay, you don't have to fix any particular property, right? But we'll give you a loan based on your undertakings,
Okay.
right? Any undertaking or your business, whatever it is, it may include even your property that is that you have and all of that, but no particular one. So you find that our collateral is floating. That's why they call it floating charge.
Okay, floating charge.
It's not fixed. Okay, because you cannot point to a particular property to say, this is what we use to secure the loan. Now, strictly speaking in law, right, the holder of a fixed charge always has priority over any other, over a floating charge holder.
But the floating...
But the floating, you have to wait until the fixed charges are done. Then they'll now...
and that will take so long.
Not necessarily. It's just a matter of procedure. I mean, if the company is
if I don't want to pay, I'll be dragging my feet.
No, you don't have that. No, there's always, of course, when I'm giving you my loan, I won't just keep quiet and let you write the agreement and tell me to sign now. All those check, there will be things in the agreement, safeguards against all actions like this that you may use to frustrate me. And that's where receivers come in. I'll just appoint a receiver. You know what? Go and even make him a manager. Go and manage the undertakings of the company. And once they enter, they start to run your company. Your directors are put aside.
Okay.
And for them, their primary concern is, before 2020, of course, was to recover the money of the principal. So there was always some hardship in that case because they are not concerned they don't care what your business becomes after they leave. So we found that a lot of companies,
after their money being
once they
paid
recover the
completely,
money, those businesses cannot continue as a going concern. They usually will just come and wind up, liquidate them. And that was why there was this copious amendment in the Act that introduced company administration and company voluntary arrangements, right? And then when you now appoint anybody as a receiver, right, his primary duty is not his principal. His primary duty is to help that company out of the woods. Yes, you want to collect your money, but it's better for you and every other person and the economy if this business still continues. You know why? It will pay you your money. It can come back to borrow more money from you and pay back.
Okay, and then save
jobs. It will secure people's jobs. And when people's jobs are secured and it's a going concern, even for the government, they will still get taxes. So in the long run, it's a win-win for everybody.
Okay.
So we're talking about the fixed and the floating charge and the amendment to Section 207.
Okay.
Now, under CAMA 1990, right, there was no direct requirement to countenance prohibition notice in the floating charge. Now, I've not explained what prohibition notice means. In the floating charge, prohibition notice will mean, I know that, yes, a holder of a fixed charge has priority over me when you want to settle debts.
Okay.
But the condition under which I'm going to give you this loan is for you to agree with me that when I give you this loan, you cannot create any charge, whether fixed or floating, that has priority over me.
Oh.
So you are prohibited from creating any other charge, fixed or floating, with priority over this one we are creating. It will not affect the ones that already exist. But any other one that will come, they must know that they cannot, if they are giving you money, they should know that I'll take priority over them. Whether they are holders of fixed charge or floating charge, it won't matter. Now, what the law has now done in section 204 is to say that a holder of a fixed charge will have priority over the holder of a floating charge. Unless, don't forget that we said for a fixed charge, there is a fixed property.
Yes, there's a fixed property.
So it always doesn't have a problem. They will settle it before settling another person. But there's now a proviso that says, unless the holder of that fixed charge has notice of a prohibition in the floating charge.
Oh, okay.
So if you are coming to borrow and you say, okay, you want to be a fixed charge holder, you are coming to lend me money, and you say, okay, that your property is what we are putting down to secure it. No problem. But know that there is a floating charge that has forbidden me from creating any other charge that has priority over him, including your own.
Okay.
So are you still willing to go ahead and lend me the money? If you say yes, no problem. So you find that this is not an exception to this general rule that the holder of a secured creditor, the holder of a fixed charge, has priority over a floating charge.
Oh, okay.
Now, the law for that says that for that to operate, that prohibition clause must be registered with the commission, with CAC. That was not the situation under 1990. But that is now the situation in 2020. Now, you find that 204 came before 207.
Yes, I was looking, I was wondering.
So there will be 204, 205, 206. And then ordinarily, in the ordinary interpretation of statutes, you say that the one that comes later, right, would be the one you give effect to, because the legislature is supposed to know that if we are saying 2 plus 2 will be 5, we already understood that somewhere we said 2 plus 2 should be 4. So that was number 4. Now we're in number 8, we say 2 plus 2 should be 5 or 6. It is taking that we're the same people that said 2 plus 2 should be 4. So if now we're saying 2 plus 2 should be 6, then it should be 6.
Okay.
You
we shouldn't break the rules.
Yeah, you don't say, no, there's no inconsistency. Yes, it may be inconsistent, but in giving effect to it, as long as it does not result in absurdity. I'm the same person that said I won't dance. And then later I said I'm not dancing. Why you say I must dance? So for the smart
people who want to change the rules while the game is on.
Yeah,
there's no room for them.
There's no room, right? Yeah. So you find that ordinarily in 207, even though 204 had said where there's a prohibition notice in the floating charge will take precedence over a fixed charge. 207 came back and said, irrespective of any provision in any act, the fixed charge holder, the secure creditor, will still take precedence over the floating charge.
Yes.
Right. So that negates the protection that 204 gave the floating charge holder. So now what BFA has done, the Business Facilitation Act, is to come back to that 207 and recognize the protection that Section 204 has given a floating charge holder that has a prohibition notice.
Okay.
So what it did was to now say, without prejudice to Section 204. So 207 will operate subject to 204.
Okay.
Right? If there is no prohibition notice, fine, 207, the holder of a fixed charge, the secured creditor, would take precedence. But once there is that notice, prohibition notice, and it is registered with the commission, then the holder of a fixed charge created after the floating charge is deemed to have notice, constructive notice of that prohibition clause. And it's also presumed to have acceded to that protection given to the floating charge. So you can't come back and say, no, I'll take precedence.
People will be more interested in the implementation date, yes. When is the implementation date?
Okay, by the act itself, because usually in making laws, the law itself will tell you when it is commencing when the application becomes applicable.
Okay.
You know, where the law itself does not mention a date, then it is deemed to commence on the date the president assents, that signs that bill into law. But in this case, the BFA itself says that the law, the act, will commence on the 8th day of February 2023, which means it has already commenced.
Oh, okay.
It commenced last month on the 8th of February. So the question there will be that, okay, what is the role of the commission in all of this? When do we want to start implementing? Truth again is that the implementation has started. Because there have been situations where there have been applications to the CAC where there were contentions on the interpretation or applicability of Section 142, for instance, you know, about this preemptive right. And when these applications came, they came earlier in the month. This was already effective, the BFA, which says now that section shall only apply to private companies, because these were contentions
as to
on
which
the
particular
applicability to public companies, whether they are satisfied that requirement or not. You know, SEC said no. The law says this and this. CAMA says go and do that before we approve your application. You know, interestingly, by the time it came to CAC, this already became law.
Oh, okay.
So it had overtaken it. So of course we had to advise that, look, that position no longer holds by reason of this act coming into force. You know, but there may still be one or two actions that may, one or two aspects of it that may require actions from the commission. For instance, we didn't get to talking about that now, but I'm sure in the next section we'll talk about it. Section 572, which defines Section 571, provides the grounds, right, upon which a company may be wound up. Once any of those grounds exist, you can actually proceed to the court by petition to wind up that company. One of the conditions is when a company is unable to pay its debts. Right? A company is owing money and it has become impossible for it to pay that money. Right? So the indication then will be that this company has gone insolvent. Right? In 1990, I think that amount was placed at 200 naira or 2,000 naira.
Okay. 1990, 2,000 naira.
I think 2,000 naira. Now, don't forget that in 1990, 2,000 naira.
It's about 2 million today. Maybe the value, roughly.
Or even more.
How more?
Right? So it was the value. Right? What 2,000 naira then commanded. Right? So by over-inflation of time and erosion of value of the naira, it became necessary that amount be reviewed. So in CAMA 2020, it was reviewed to 200,000 naira.
Okay, 200,000.
Again, when CAMA 2020 began, right, it started more than the process of amending it, the first draft and all of that. It started more than 8 years before, about 10 years before it became law. Right? By the time it became law, 200,000 naira was no longer.
So events have overtaken that
again.
Yeah.
So now, realizing that it may not be practicable for you to leave, it to defeat the whole purpose, for you to leave such a matter in the substantive legislation, that is CAMA. Every time you need to review that amount, you have to go to the National Assembly. What BFA has done is to remove it, right, from the scope of the substantive law, the act itself, and say such amount as the commission shall by regulation prescribe. So what that means is that we now have to prescribe an amount by regulation. So that's something that CAC has to do by way of implementation.
So when will that be?
Well, we're putting that together, I'm sure, very soon. That and maybe one or two other things. We may also need to issue
what amount are we
guidelines.
200 million?
Well, that is not
20
something.
million?
That's not something we have. But it must be practical.
Because there's further devaluation of the naira.
Yeah. But again, the good thing is that from time to time we can, when we feel the need to do this, we can. Because don't forget that we're talking about conditions that will activate a petition for winding up.
Mr. Tolulokpe Adeola, many thanks for your time.
Thank you very much, Madina.
Great insight from Mr. Tolulokpe. Let's move to business registration. Are you planning to register an association, club, or a faith-based organization? Please come with us as we show you how to do just that seamlessly online.
Registration of an incorporated trustee on the new CAC registration portal. In this video, you will learn how to register an association or incorporated trustee with the Corporate Affairs Commission. Let's begin. Step 1. Log on to pre.cac.gov.ng and log into your portal. If you do not have an account, click on Register on the top right corner of your screen to create an account. Step 2. On your dashboard, click on New Name Reservation. Pick Incorporated Trustees under Classification. Enter your proposed names. Pick New Incorporation as your reason for availability search. Click on Apply for Reservation Code button. This will bring up the reservation code application process page. Step 3. Pick the classification of your Association 1 and 2 and describe the association's classification. Ensure you fill all fields marked with a red asterisk and click on Save and Continue. Step 4. On the Constitution, specify the minimum or maximum number of trustees. Set the trustee tenure. Choose the custodian of the common seal. Choose the governing body of the association. State the application of funds. State how the account of the incorporated trustee will be kept, then click on Save and Continue. Step 5. Under Aims and Objectives, click on the Add Aims/Objectives button and state the aims or objectives of the association. Click the Add button, then click on Save and Continue. Step 6. On the Trustee, you must add at least 2 trustees or more to proceed and ensure you add a secretary to the body of trustees. To add a secretary, pick and fill in the details of your designated secretary or a trustee who will also act as a secretary. If the secretary is a designated secretary only, click the box labeled Add as a Secretary Only after filling in the secretary's details. If a trustee will be acting as secretary, click the box labeled Add both trustee and secretary and click on Add Trustee and then click on Save and Continue. If you wish to hide the residential address of any of the trustees, click on the Hide Residential Address toggle button. Ensure you fill all fields marked with a red asterisk and click on Save and Continue. Step 7. Under Document Upload, if there are supporting documents which will facilitate your application for a reservation code, scan and upload here. Then click on Save and Continue to preview. Preview your entries and if satisfied, click on Save and Continue to proceed to payment. You can now proceed to make a newspaper publication in at least one national daily and at least one local newspaper in local circulation in the locality where the association will be registered. Obtain and keep the hard copies of those publications. Registration. After your application for consent has been approved, log on to your dashboard and click on the Reserved panel. Click the Start Registration button beside your reserved name. Step 1. Under Meetings, you can add different types of meetings and specify the quorum for each. Add your meetings and click on Save and Continue. Step 2. Under Source of Income, add the sources of income of the association and click Save and Continue. Step 3. Under Publications, fill in the details of the first and second newspaper publications you made and click on Save and Continue. Step 4. On the Document Upload, scan and upload the document labeled Yes, and where the document labeled Optional applies to you, scan and upload, then click Save and Continue to preview. Preview your entries and if satisfied, click on Save and Continue to proceed to payment. When your registration has been approved, your certificate will be automatically generated on your registered panel, where you can download and print.
Wow! It's so easy. What are you waiting for? Hurry now to pre.cac.gov.ng to register your business. And that does it for this week's edition of the program. We do hope you enjoyed watching. Now, for comment and questions, you can take advantage of our social media handles and our helpline. On Twitter, it is CAC Nigeria 1. On Instagram and Facebook, it is Corporate Affairs Commission. Our email is cservice@cac.gov.ng. You can reach us via our website on www.cac.gov.ng and our helpline on 070-806-29000. Do join us next week for another interesting edition of the program. Same time, same station. From me, Medina Atzaki, and the whole team here, it's bye for now.